I'm Sarah Gillis-Sanu, and I'm team leader and communications assistant for the Office of Marketing Communications here at the Nick School. And I'm really excited to get to introduce Kevin Smith, who is the director of the Office for Copyright and Scholarly Communications. He's a lawyer and a librarian, and he's going to be able to give us some insight into how to protect ourselves from copyright infringement and also how to keep ourselves from committing copyright infringement. So we're really excited we could have the time today to come and talk to us, and I hope you all have some questions prepared. All right, thank you.
Great, thank you very much.
And Kevin, you should know that you're also talking to the Marine Lab.
Right. Hi there. Hi there.
And Erica Rao in New York. So,
hi.
Sorry.
And I want to start by saying that I would appreciate it if you all have questions, whether you're in New York or Beaufort or here, please let me know and ask them as I go. I'm very bad at leaving time at the end of a presentation, but I'm very, very willing and would prefer to address things that you think of that are real problems rather than what I was guessing at would be the helpful things for me to say. So please do that. And I was told to remind you that you need to push the button on the microphone in front of you, at least if you're in this room, in order for your questions to be heard in New York and Beaufort.
Oh, thank you.
So I'm, as I said, nominally, or as Sarah said, I'm not only going to talk about copyright and social media, but as I said, I have things to say, and if you would rather talk about something else, let me know. So obviously, as this recent little contretemps about Facebook reminds us, people are very confused about copyright. You may know that in response to Facebook's small change in their terms of service, people started posting this message in their Facebook status. In response to the new Facebook guidelines, I hereby declare that my copyright is attached to all of my personal details, illustrations, comics, paintings, professional photos and videos, etc. As a result of the Berner Convention. For commercial use of the above, my written consent is needed at all times. People thought that they needed to act to protect their rights in stuff that they posted to Facebook. Almost everything in this statement is wrong, and it was completely unnecessary, as I think a lot of people realized pretty quickly. In fact, the things that you create, your posts to Facebook, images, videos, blogs, anything that you create like that is protected by copyright automatically, and Facebook's terms of service do not change that. What they do is create a license for Facebook to use the materials you post to Facebook in certain ways, but they do not change the copyright status, and you don't have to post this in order to have a copyright. Another thing that's wrong about this is that there are some things that you can't protect with copyright. Facts and short phrases, personal details, my name, where I went to college, where I work. Probably I cannot protect that with copyright, and putting this in my status wouldn't change that either. One more thing, the Berne Convention is an international agreement on copyright that harmonizes the laws of 150 countries and tells us how copyright gets enforced in different countries. It is not the Berner Convention. There is no such thing as far as I know. It is the Berne Convention, and it really didn't have any effect on what that statement is trying to say. There is only one piece of this statement that is in fact true, and that's the last sentence. For commercial use of the above materials, my written consent is needed at all times. Well, it doesn't necessarily have to be written, but if you are the copyright owner, your consent is required if somebody is going to use your material in ways that infringe or impinge on one of the exclusive rights in copyright. Or there may be an exception that allows the person to do that without your consent, but it probably wouldn't apply, whatever exceptions, they probably wouldn't apply to commercial use. So most everything in this was wrong, but it does at least illustrate to us that folks are very confused about copyright and how it applies in social media or online in general. So here's a little quiz. Are these tweets copyrighted? So let's start with this one. No set of laws can end evil, but there's no excuse for inaction. That was something Barack Obama tweeted after the Newtown shootings. Protected by copyright? Oh, take a guess. Come on.
No,
Why not?
because he just makes statement. You know, it could be any statement. There's nothing.
Well, actually, it's probably original enough to have copyright protection. The standard of originality is very low. The reason it doesn't have copyright protection is because works of the federal government, works created by an employee of the federal government in the scope of his or her employment, are simply not protected by copyright. That's a policy decision that was made long, long time ago and has always been a part of our copyright law. So, as a private citizen, if Barack Obama wrote this, he would probably get copyright protection. But as President of the United States, he does not. A hashtag from a conference. Speaker just said, research is cool. Okay, I made this up. But it's the quality of the kinds of tweets you get during a lot of conferences, after all. Is it protected by copyright? Probably not. Mostly because it's a quote from somebody else. The person who tweeted this really didn't say anything original. I like this one. Don't be so humble. You're not that great. I'm just going to go through these. Probably not protected by copyright for the person who tweeted it because it's a quote. It's a quote apparently from Golda Meir, who supposedly said it during a cabinet meeting. I would love to have attended one of those cabinet meetings. Compassion is the thief of joy, one of the most tweeted phrases, I'm told. I don't know why. Comparison is the thief of joy. But again, it's a quote. Probably not protected for the person who is tweeting it. All's fair in love and war. Same thing. So probably none of these are actually protected. But I actually bring it up to say it is possible, and I've seen this debate, it is possible for tweets to be protected if they're sufficiently original. I said short phrases aren't protected. It's hard to know exactly where the boundary line is. But you can have copyright protection in a single sentence if it meets the standard of originality, which almost none of these do, except perhaps for the president's, and he doesn't get copyright as a matter of public policy. In addition to all this confusion about social media, I do think there's kind of a bigger problem. You all know the fuss between the Oatmeal and BuzzFeed? Let me get it right. Oatmeal is a comics site. The BuzzFeed wrote a profile of the founder of the Oatmeal, who is apparently relatively controversial. It said all kinds of nasty things about him based on a Facebook profile of him that made him sound like a racist, far-right extremist, and turned out to be fake. BuzzFeed based their profile on a fake Facebook profile. Or how about Ryan Lanza and Adam Lanza? Do you remember that when the Newtown shootings happened? Initially, social media identified the shooter as Ryan Lanza, and his name is still out there as the killer in Newtown on the internet. It will always be there, but it was wrong. It was his brother Adam. And then there's the professor who has written a blog post saying he doesn't believe the shootings happened at all. But that's a different problem. I think the bigger problem is simply that the internet is so fast and so ubiquitous that mistakes happen before the filters kick in, and everyone, literally everyone, sees those mistakes. So there's nothing about social media that actually changes the copyright rules. It just makes them a lot easier to infringe because you can do things so quickly and they are so irretrievable. And they're distributed to a few million, nowadays a few billion of your closest friends. Prompts me to say, I've mentioned the exclusive rights of copyright and that when you make a mistake, it's distributed to everybody. The exclusive rights in copyright are 5. There's actually a sixth, but it's not very important. The 5 rights in copyright. A copyright holder has the exclusive right to authorize people to make copies of their work, to distribute their work, to make derivative works from their work, to publicly perform it, and publicly display it. Some works are more easy to display, and some works more easy to perform, obviously. Clearly, the internet makes it really possible to do all of those things very fast and to a lot of people. So it does make the situation more intense, but it doesn't change the rules. So here are the basics. Some of these I've already said. These are the basic foundations. Copyright is entirely automatic. This is really hard for people to grasp, that you don't have to do anything to get a copyright except fix original expression in tangible form, which you are all doing if you're taking notes. You are fixing original expression, probably yours, although you might be copying what I say verbatim, in tangible form. The standard for originality is extremely low. Anybody know what is so unoriginal that it didn't get a copyright in the United States? It's a relatively famous, kind of silly Supreme Court case. The white pages of a phone book. Believe it or not, there was a Supreme Court case over the white pages of a phone book. Turns out the companies copied phone books from one another. And because they don't want other people to copy their phone books, some companies insert deliberate errors. They insert people who don't exist so that they can look at their competitors' phone books, and if those people are in there, they know that their phone book has been copied. And then they sue one another, and it goes all the way to the Supreme Court. I realize that in the age of the internet, even phone books are kind of an outdated concept. But the Supreme Court said that a phone book, the white pages of a phone book, were not original enough to have a copyright. They were not, to use another phrase from the copyright law, a work of authorship. We say authorship in copyright no matter what we mean, whether we mean photography or film or dance or any of those things. But anyway, the Supreme Court said just the facts, the fact that Kevin Smith lives on Sorrells Creek Lane in Raleigh and has this phone number, is not a protectable expression. It's not a work of authorship, it's just a fact. And you can get a copyright in the original selection and arrangement of facts. It's the only way to protect data sets. But the Supreme Court said, never mind, alphabetical is not original. So the white pages of a phone book don't have copyright protection. Do you think the yellow pages would? Yes, absolutely, they would. The selection and arrangement is different. There is artwork, there are slogans. There's plenty of things in the yellow pages of a phone book that would be original enough. So the standard of originality is very low. If you're taking notes here, you certainly have a copyright. We like to say that probably your grocery list has a copyright. I've never heard about it being litigated, though, although if they sue over phone books, who's to say they won't sue over laundry lists or grocery lists? Copyright is owned by the person who fixes the original expression, or who creates the original expression. The author. Again, we use the author to mean the person who creates a film, a photograph, a whatever you call a set of choreography, an architect who designs the plans. All of those things have copyright. All of those copyrights are owned originally by the creator, except in the case when something is a work for hire. Something is a work for hire if it's created by an employee within the scope of his or her employment. Now I know it sounds like that means that everything that's created at a university is work for hire. And that would probably be the case, but most universities have policies that say we don't claim ownership in things like the traditional works of the faculty, the journal articles and books that they write. At Duke, it's not even clear that Duke claims ownership in the things that staff create, which could actually be problematic in my opinion. But this presentation that I wrote probably is owned by me, even though I did it as a Duke employee for the purposes of making a presentation to a Duke audience. Yeah, good, because I was going to say, I've just spewed out a whole lot of facts about copyright law. It's time for you to ask questions.
Yeah, I was curious about how commissioned works fit into that work for hire.
That's a really good question, and it's one, again, that the Supreme Court had to decide about 40 years ago.
Sorry, can you repeat the question? We couldn't hear.
She didn't press her button. The question was how commissioned works fit in to the work for hire rule that I just mentioned about. Ordinarily, something is a work for hire if it's created by an employee within the scope of her employment. The question was, what about commissioned works? First thing to know about commissioned works, just paying for it is not good enough. Just because you pay me to create something, why you would do that, I don't know, but let's assume that you did. You pay me to create something, that does not mean that you own it. That was, in fact, the case in the Supreme Court case where a group called the Community for Creative Nonviolence commissioned a sculpture to bring attention to the problem of homelessness. The sculpture is a picture of the Holy Family, Jesus, Mary, and Joseph, living on a subway grate. And it says there's something about the homeless are still with us. Anyway, they paid a lot of money for it. And then they got into a dispute with the artist about whether or not he or the organization controlled future uses of it, making copies of it, selling them, that sort of thing. The Supreme Court said that the artist still owned the copyright. Just because the Community for Creative Nonviolence had paid for it did not make it work for hire. For a commissioned work to be work for hire, two things have to be the case. First, it has to fit into one of 9 categories that are specified in the law. Actually, not a lot of stuff fits into those categories. Music does, contributions to a film do. Of course, that's indicative of how good the lobbying for the recording industry and the film industry is. They wanted to make sure that they got into that list. A lot of the things that you would commission somebody to create probably wouldn't fall into one of those categories. And then the second condition is there has to be a contract that explicitly says this will be a work for hire. So it's very, very hard for a commissioned work to be a work for hire, to be owned by the person doing the commissioning. Most of the time, the creator will continue to own the copyright. What I usually tell groups that are commissioning, well, I've worked with news and communications when they've been commissioning a piece of music or a video. What I usually tell them is to make sure you have an agreement in advance that says this is a work for hire, and if for any reason this is not a work for hire, I, the artist, hereby transfer the copyright to whoever is getting. In other words, belt and suspenders. If one doesn't work, you make sure you have the other. You have a statement that it's a work for hire, and you have a transfer of copyright in case it doesn't fall into one of those work for hire categories. Okay? I think you had your hand up.
Oh, yeah. I was just going to ask, for the work for hire, does the copyright automatically get transferred to the employer?
The fiction that the copyright law uses is that the employer is the author. That's how work for hire is defined. In these situations, the employer is the author. Of course, the employer is often an entity, and we know that companies don't actually create anything. People who work for them do. But yes, the copyright then is initially owned by the employer if it's a work for hire. There's no transfer, there's nothing. The employer is defined as the author from the beginning. I have a list up there of the things that are protected by copyright: text, photos, paintings, music, film, choreography, architecture, recorded performances. All of those things have copyright protection. Interestingly, we have changed the rules about architecture. It used to protect just plans, but now the buildings that are constructed from those plans are protected by copyright. Which led to an interesting case. A man took a photograph of a very distinctive building, the Rock and Roll Hall of Fame in Cleveland, and decided to sell his photograph because it came out really well. The Rock and Roll Hall of Fame said, no, you can't do that. our building is protected by copyright, your photograph is a derivative work, you can't sell that photograph. And the courts agreed with the Rock and Roll Hall of Fame, and Congress didn't like that result, so they actually added an exception to our copyright law that says that you are allowed to take a photograph of a building as long as you're in a publicly accessible place. You're not trespassing to take the picture. You're allowed to take a picture and do whatever you want with it. But we had to change the law to add that exception because copyright is very, very pervasive. Yes?
Most of these folks in here write blogs for the school,
right.
Their students. So does the copyright, is it theirs or is it the school's?
It's theirs.
Yeah.
To the green one.
Oh, I'm sorry, yes. The question was people who write blogs for Duke. Is the material that they write for their blogs owned by them or by Duke? Short answer is it is owned by them. It could only be considered a work for hire and therefore owned by Duke if it was part of their regular employment, within the scope of their regular employment. Now, some of them may be employed to do exactly that, but then Duke also has a policy that says that the creative work of members of the community is owned by those community members, except in very specific, defined circumstances. Blog wouldn't fall into that. If you design a piece of utilitarian software that accomplishes something that Duke wants done, that falls into one of the categories, one of the exceptions. But a blog would not. It's owned by the students.
What about photos? Like I shoot photos for the school, and it is part of my job, but it's not specifically what I'm hired to do. Are those photos Duke's photos?
My opinion is that those photos are owned by you. So yeah, Duke's policy is pretty comprehensive in saying that the copyright in materials created by members of the Duke community, that's the language it uses, are owned by the creator, except in those specific exceptions. I don't think your photographs would fall into one of those exceptions. I don't think blogs would. With students, it's always iffy because there's a question of whether or not they're doing it within the scope of their employment. Some students aren't employed and still create, well, all of our students create all kinds of wonderful stuff outside of an employment relationship as well. All those things are owned by them. So having gotten through those sort of foundational rules, the presumption is that we have to assume that material on the internet is protected. I sometimes hear people say, it's in the public domain, I found it on the internet. Those are two different things. The public domain is a legal concept that I'll tell you a bit about in a minute. But public availability is not the same as the public domain. So no matter how widely something is distributed on the internet, that does not mean it is free of copyright protection, and we have to assume that such things are protected. It's not required that it say, copyright 2013 Kevin Smith. That used to be required in our law. It is not required anymore. Just because it says nothing, you still have to presume that it's protected. And copyright lasts a very long time. It has to last under the Berne Convention. Remember the Berne, not Berner Convention? Under that international agreement, every nation that participates in that agreement, and that's 150 countries around the world, everybody who's a member of the World Trade Organization, every country is required to protect copyright for at least the life of the creator plus 50 years. And in the United States, we protect copyright for the life of the creator plus 70 years. And the reason I have a picture of Sonny Bono there is because the bill that extended copyright protection for those additional 20 years is called the Sonny Bono Copyright Term Extension Act. Bono was a member of Congress, as you may recall, after he was a pop singer of sorts. And he was killed in an accident, skiing accident. And the bill was passed shortly after his death, so it was named in his honor. It is sometimes referred to as the Mickey Mouse Copyright Extension Act because copyright seems to get extended every time Disney is afraid that the copyright in Mickey Mouse will expire. One of the interesting effects of this, it used to be that we gave copyright protection for a term of years in the United States. We were one of the only countries that did this. The term of protection was 28 years, and it could be renewed for another 28 years, maximum of 56 years. It was possible, certainly very likely with things that are created by folks your age, that you would outlive your copyright. It is no longer possible to do that. Your copyrights will persist for 70 years after your death, as will mine. It's just probably coming quicker for me. But so everything, even though the author is dead, everything is protected past the time of the author's death, which means copyrights pass to heirs. Heirs often have no idea that they own the copyrights in their ancestors' works. So it becomes very, very hard to figure out who to ask. In the libraries, we digitize lots of collections. We have strong collections in documentary photography. A lot of those things were taken by people who were more or less amateur photographers who are now deceased. Their children own the copyrights. Often they have no idea that they own copyrights, and we have no idea how to contact them. In other words, this provision of the law has created a lot of what we call orphan works, works that are still protected by copyright, but where it's impossible to find a rights holder. So I say here that public availability is not the same as the public domain. So what is the public domain? It's a very specific legal concept. We celebrate the Public Domain Day every day on January 1st because this happens to be the sign from 2012, and I couldn't find one for 2013. On January 1st of each year, everything whose copyright expired the previous year goes into the public domain. That's just to make the math easier. Because of some really quirky things that we did with our law, in the United States, any published work published 1923 or after may still be protected by copyright. But if it was published in 1922 or before, it's in the public domain. And that's not changing, actually. For published work, nothing is going into the public domain in the United States and won't until January 1st, 2019. Yes. If you ask me to explain the math, it's
No, it's okay.
Okay,
my question isn't really about that. So I guess what I'm wondering is if you had a composer who wrote a piece before 1923. So, I took a class here. I should know better. Sorry. So my question is, if you had a composer who wrote a piece of music before 1923, so copyright on the piece of music has expired, but someone performs that piece of music somewhere else and it's recorded, who holds the copyright and how does that work?
Great question. And music copyright is one of the most difficult things to deal with. But so I'm going to answer the question you asked and the one I thought you were going to ask.
Okay.
The one I thought you were going to ask is the piece of music was written before 1923, but an arrangement was done afterwards. And in fact, the arranger will hold a copyright in the arrangement, although the arranger can't prevent somebody else from taking the original piece of music and making their own arrangement once copyright is expired.
Makes sense.
Recordings. Copyright, people get copyright for their recordings. So this is even worse than imagining commissioning an artwork from me. But suppose I make a recording of a piece of music. I'm the world's worst singer. So, and it's an old piece of music, but I record it. I have copyright in my recording, but I cannot prevent you from making your own recording. Okay, I can prevent you from using mine in any way that I don't give you permission for or that isn't covered by one of the exceptions, but I can't prevent you from making your own recording. That's true even for modern pieces of music. We have specific rules in our copyright law that allow covers, basically. The performer cannot prevent another performer from making a cover. However, the second performer will have to pay a licensing fee to the original composers or whoever owns the underlying music, but there's an automatic license. In other words, the law requires that that license be granted and it sets the fee. So we've made it possible for people to make covers. But music is extremely complicated. Going back to what's in the public domain. Things that were published before 1923, and I told you January 1st is Public Domain Day. So on January 1st, 2012, the works of authors who died before 1942, 1941 or earlier, went into the public domain everywhere except the United States. And that was a significant day because the works of James Joyce went into the public domain on January 1st, 2012. He died in 1941. Everywhere except the United States. And in the United States, because of this odd math that we did, nothing published is going into the public domain until 2019. Because we made this transition to life of the author plus a term of years, we pulled everything in, but we set a rigid term. We said everything's going to be protected for 95 years. Everything that was created before, we changed the law. And everything that's after will be protected for life of the author plus 70 years. I know, I shouldn't do this. I shouldn't even start the math. But the result is that Ulysses is in the public domain everywhere in the world except in the United States, where it will be protected until 2019. Which is significant. I'll tell you why in a little bit. Ideas. Ideas are never protected by copyright. I'm going to say it again. Ideas are never protected by copyright. Copyright protects expression, the actual way you say something, not the underlying ideas. Which means if you want to write a play about star-crossed lovers whose family are keeping them apart, you can do that and you're not infringing Shakespeare's copyright. Of course, Shakespeare doesn't have a copyright. But you're not infringing Leonard Bernstein's copyright in West Side Story if you write that play. Ideas are not protected. Expression is protected. Let me just say before I answer questions, that line is not at all clear. Our courts have said, for example, that you can protect a literary character. So we prevented, a couple of years ago, a man from publishing in the United States a sort of updated version of Catcher in the Rye, where the 76-year-old Holden Caulfield revisits New York. The court said that the character of Holden Caulfield was constructed from expression and therefore was not just an idea. And they prevented somebody from writing a new book about a 76-year-old version of Holden Caulfield because he did things like call people phonies. And the court thought that that made it a potential infringement of J.D. Salinger's copyright. I think the decision was wrong, but that's what the court decided. Go ahead.
So how does that work with intellectual property? Because I was listening to something on NPR the other day that was implying you can have intellectual property rights.
Intellectual property is the broad phrase that we use to refer to patents, trademarks, and copyright.
Okay.
So copyright stuff is intellectual property. What you were hearing on NPR was probably referring to patents.
Yes.
The difference between a patent, well, there are a lot of differences between patents and copyright, even though we call both of them intellectual property. A patent does protect an idea. It's much harder to get a patent. You have to have actually made something, or at least you used to have to. The courts have been kind of weird, but you have to have invented something, and you can actually get an idea, a patent that all patents protect the idea, so that other people can't create new inventions that do the same thing. Whereas people can independently write a book that reflects the same ideas. So they're just two different forms of intellectual property. I'll give you an example about how copyright does not protect ideas. And in the process, you all know the book or the movie, The Da Vinci Code? Good, because I'm going to ruin it for you. If you don't know the story, don't listen to me. I'm about to ruin it. The story of the Da Vinci Code is actually almost completely based on a book that claimed to be a work of history called Holy Blood, Holy Grail, that was written 20 years earlier. And the thesis of this historical work, Holy Blood, Holy Grail, is that Jesus survived the crucifixion, married Mary Magdalene, had children, and has descendants who are running around today. Well, of course, if you know the Da Vinci Code, that's the secret that they're all protecting, right? I told you I was going to ruin it for you. That's the secret in the Da Vinci Code. And Dan Brown knew he was using Holy Blood, Holy Grail. Even one of his characters, his name is actually an anagram of one of the authors of Holy Blood, Holy Grail. So he was not only knew he was doing it, he was being a smart aleck about it. He got sued for copyright infringement by the publisher of Holy Blood, Holy Grail. He won the case. Dan Brown did. It was in the UK, but that wouldn't really matter. And he won the case because the court said all he took were these ideas. Historically harebrained ideas, but ideas nonetheless. And he hadn't infringed any original expression from Holy Blood, Holy Grail. So that gives you an idea where the line is. It's not real clear, but it's somewhere between what Dan Brown took and the character of Holden Caulfield. Yeah, please.
And I was wondering about the difference between countries. So you said that case was in the UK and
right.
from England. So something that's not protected in the UK anymore but is in the US, how would you deal with that minefield?
Yeah, and it's especially hard in the internet age because everything is pretty much everywhere. What the law says is that whether or not a work has a copyright, whether or not it's risen into the public domain, we would say, is determined by the law in its country of origin. But always, this is what the Berne Convention says, always we will apply whatever is the shorter term. That's what the Berne Convention says. We determine what the term is in the country of origin, what the term would be in the country where the use is happening. We apply the shorter term. It also says, this is called the principle of national treatment, that anybody who signs the Berne Convention, as I said, it's 150 countries, all the members of the World Trade Organization, including the UK, of course. All members of the Berne Convention get the same protection in any given country that citizens of that country would get. So here in the United States, your copyright is protected exactly the same way mine is. And if I go to the UK, my copyright in the UK is protected exactly the same way yours is. In fact, they're very similar now because of this harmonization attempt that was carried out by the Berne Convention. The principle on which the Dan Brown case was decided, that ideas are not protectable, is almost universal in copyright law. So it's the same in the UK and in the US. Okay? And by the way, the US ignores that rule about the shorter term because of this odd math that we did and protect everything for 95 years. So it is the case that the work of James Joyce, who was a citizen of the UK, is in the public domain in his native Ireland, but is protected in the United States. I don't know what would happen if a lawsuit came up in the United States, if our courts would say, no, wait a minute, we're supposed to apply the law of the shorter term, or if they would accept this strange revision that we made. We were doing it in order to protect copyrights that might otherwise have expired early because we had those rules about the notice and registration and all those sorts of things. So once we got rid of all those laws, we said, well, we have to protect the people whose works, foreigners, whose works would have been in the public domain in the United States. So we're going to give them all this 95-year protection. And that resulted in our protecting works that are in the public domain in their own countries. The other thing I want to say about the public domain is that republishing something that's in the public domain does not revive its copyright. So suppose I take a photograph of a public domain artwork and then I post it on the internet. Do I have a copyright in what I've just posted? I put it in my blog. I take a picture of Rembrandt's The Night Watch and I put it in my blog. Do I have a copyright protection on that image? You're working on an answer. Where are you getting to? What do you think?
I think yes.
You think I do? Logic would suggest that I do. In fact, probably I don't. So let's start at the beginning. The work is in the public domain. Now, I should get a copyright when I take the photograph. Because the photograph is a derivative work that I'm creating, I should get a copyright. there is a case in the United States that says if the image, the photograph, is nothing but a slavish reproduction, that's the language the court used, of a public domain original, it's not itself original enough to get copyright. And it was specifically in the art context, where the images, the photographs, were just reproducing the painting. There was nothing else in them. They were just trying to make faithful reproductions of the painting. Court said since the original painting was public domain, the photograph is also public domain because it adds nothing original. I like to say that if I take a perfect reproduction photograph of the night watch, I don't get a copyright. If I pose my wife in front of it going like this, it's really tacky, but I get a copyright for that because I've added something original. And then I put it on the internet. That doesn't change the analysis either. Even though presumably, well, let's assume, for instance, that my photograph was not digital to begin with. I had to scan it. So I did some work on it. I transformed it in another way. Still doesn't get me a copyright. That image that I put up on my blog almost certainly does not have a copyright. Now, the things I write in my blog about that image, of course, I have a copyright in those. But if somebody comes along and just captures that image that was in the public domain to start with, I have nothing to say about it. Likewise, a painting that's reprinted in a book. The book was published in 2010, but the painting was done in 1538. I can scan that page of the book and use the image of the photograph as long as I don't use any original expression that was published for the first time in the book. Yes, ma'am?
Now we know why so many books about old art and classical music are around. I had a really specific question that has a little more to do with the internet. So for one of my blog posts, I decided to write about carbon calculators, and I wanted to show
about
carbon calculators.
Carbon
so
calculators.
Calculating your carbon footprint. And
Okay.
I wanted to show 2 different carbon calculators, and because it's good to include pictures, I took screenshots of the carbon calculators I used, and I said, you know, this is the website where this is from and all of that. And I'm just wondering, like, could they, if they wanted to, get me in trouble for that, for taking a screenshot?
Great.
Sounds like yes, but...
Great question, and I'm going to answer it by going to my next slide. And
Okay.
almost the rest of what I have to say is in answer to that question. Cool. When you're using something that is potentially protected by copyright, there are 5 questions to ask yourself. If you ask yourself these questions in this order, you will probably not get in trouble. Now, none of these questions are easy to answer, but that's another matter. First question, is there a copyright at all, or is it in the public domain? So let's ask about those screenshots. Do you think that their original is protected, or is it in the public domain?
They had little images and they had a map. I mean, a map is facts, but the expression of the map can be...
Maps are protected by copyright.
Yeah, right. So what's on the map is a fact, but the expression of it is a copyright.
Right.
So I would say that that part of it would certainly
The
be.
very earliest forms of copyright were just about being developed at a time that Europeans were exploring the world. So actually, maps, even though they do seem to be factual, or their attempts to be factual, were one of the first things protected because they were incredibly valuable. So we've always protected maps and copyright. Yeah, I think you're right. I think that what's on that website is almost certainly protected by copyright. So the first question here is, the answer is, there is a copyright. Second question to ask, does a license apply to my use? Am I getting the image, for example, from a database that Duke licenses, like AP Images or ArtStore? Is there any kind of license that applies? Because I have to follow the licensing terms first. All right? They take precedent. In this case, is there any kind of license? The only thing to look for is down at the bottom of the web page, have they perhaps used a Creative Commons license?
I don't remember looking for that, so I'm not sure if it was there or not.
Probably not. Now, if you go to the Duke Library website, for example, you will see a Creative Commons license at the bottom that says, we're the copyright owners in this. We give you prior permission to make all kinds of, I think we say non-commercial uses, and whatever use you make, share it under the same license with everybody else. Because we used to get lots of requests for the websites about plagiarism on the Duke Library site. And we got tired of answering them, so we put a Creative Commons license on the bottom. And now we get questions that say, does that Creative Commons license mean that I can use this page? Yes, that's what it means. So look for a license. Lots of websites, lots of images, everything on Wikimedia Commons, about a third of everything in Flickr is under a Creative Commons license. So look to see if there's a license. Let's assume there is not in this case. So they don't say, here's a license under which you can use my work. What do you have to assume?
That there isn't one?
That there isn't, and it's protected. We already know it's probably not in the public domain. There isn't a license. Is there a specific exception in the law for my use? I told you about taking photographs of a building. So this is the third question you ask yourself. Is there a specific exception? There are lots of specific exceptions. About 23 chapters of the copyright law is all exceptions. However, you're just going to have to take my word for this, Sarah. There is no exception that helps you here. Generally, actually, the exceptions, except for the one that allows performances of films and showing slides and such in a face-to-face classroom and online. There are two exceptions that allow that. Neither one is going to get you to where you want to go because you're not doing it's not a closed teaching environment. It's a public blog. So, the first three questions we've answered in your case, and we're still out of luck. Next question, is it fair use? Fair use is this very short, very broad, very flexible, very indeterminate exception in U.S. copyright law. It is one of the things that is pretty unique in U.S. copyright law. The law of Japan and Israel also have fair use provisions. The UK, to go back to that question, they have just proposed a set of copyright reforms that would bring in a lot more fair use-like rules into their copyright law, partly because the current Prime Minister was apparently told by the founder of Google, we couldn't have founded our company in the UK because we need fair use. And there's no fair use in the UK law. And that sort of freaked him out because they'd like to have companies as successful as Google in the UK. So that's the anecdote, at least, about where this push for copyright reform in the UK came from. Fair use is never certain in advance. We only know for sure that something is fair use when 9 people tell us that it is, and those are the justices of the Supreme Court. But most things don't get that far. What we're actually told to do about fair use is to apply a set of factors. Those factors are really ways of telling us to look very carefully at the circumstances of the use we're making and decide whether or not it's fair. I will come back to that extensively. Last question you ask yourself is, who should I ask for permission? Because if you've gotten this far and the answer has been, it's protected, there's no license, there's no specific exception, it's not fair use, then you need to ask for permission. You can always do whatever the copyright holder tells you is okay. Permission always is good. Sarah doesn't want to have to track down the folks from this website and ask for permission. Do you?
Not really, no.
So, we're going to assume that your use is fair use, and I think it probably is. And we'll tell you why in a minute. I want to stop, though, and see if there are any questions about those 5 questions. It's very important to ask yourself these questions in order. As I said, sometimes it's very hard to know for sure, for example, whether or not the work is actually in the public domain. And the other one that's always uncertain is fair use. But fair use is a huge friend to people in higher education. It really is. It's also a huge friend to the internet for reasons I'll tell you. So can I go on to fair use? Okay. Fair use is, as I said, this flexible exception to copyright. It's called a balancing test, which basically is what courts call it when they say, we're going to do whatever it is we want to do, and then we're going to make up the law to fit what we decided we wanted to do. That's not cynical. That's what's called legal realism, actual theory. Another way to look at this is fair use is a risk analysis. Fair use is deciding how likely is it that somebody would care enough to complain about my use and actually sue me? And by the way, I'll say now rather than later, what do you suppose would happen, Sarah, if the people who designed these websites was really ticked off at you for what you said in your blog and wanted to make trouble for you?
I mean, I'd be surprised if they bothered, because either way, they're getting more traffic to their website than they would have if I hadn't written anything. But I guess if they did, the worst thing that they could do is be like, that's not true, and here's why.
Well, the worst thing they could do would be to bring a lawsuit against you and ask for statutory damages, which would be, for those two websites, in the amount of about $300,000. But they're not going to,
right?
Yeah.
You want me to pull it down right now, Sarah?
But that's good, because what they would actually do, it costs them almost the $300,000 to bring a lawsuit. They don't want to sue you over that. What they will do is demand that you take it down.
Yeah.
And that'll be the end of it. That's how most of these disputes end. Very few of them actually start, because fair use really does protect you in this case. But even if it did get to the point where the rights holder has said, I don't like what she said about our site, and for that I'm going to use copyright law to stop this, the best they could do would be to make you take it down.
But even then, they can only make me take the pictures down. They can't make me take down what I said, because that's my copyright.
Correct. It's also protected under the First Amendment of the US Constitution. So yes, that's correct. All right. So, fair use. The statute, the actual provision of the law, it is Section 107 of the Copyright Act, tells us that there are 4 factors to look at. And as I said, they are really about what are the circumstances of the specific use. So they say, let's look at the purpose and character of the use. Well, what are you doing with those websites? Well, you put it on a blog. You're not selling it. It's non-commercial. It certainly is published in the sense that it's available to anybody, but it's non-commercial. It's more or less educational. I mean, you're comparing these two things, looking at the features of, you're commenting on it. That's really important. That probably makes this factor favor you. What's the nature of the original? Well, it's a website itself, so it's available to everybody. It's not like people are seeing something that was otherwise hidden. You're not reporting any trade secrets. You're not showing people something that was never seen before. We do presume it's harder to make a fair use of something that's unpublished, but if you're using something that's already on the internet, it's going to be a little easier to make fair use. There's a good reason for that. You know, I have a shoebox full of poems that I wrote in college under my bed. They should stay there. They should never be seen by any human eyes. So it would be really unfair to me if somebody came along and published those things without my permission. I get that first decision about whether or not to make them public. It's hard to overcome that in fair use, but not impossible. In this is a very different case. Those carbon calculators are already out there. You're using them for something educational. I think on the first 2 prongs of the 4-factor balancing test, you're really good. The amount and substantiality of the portion used. Well, you use screenshots, right? Mm-hmm. Nobody can use the screenshots that you used to make the calculators work.
No.
They have to go to the original website.
And I included links.
And you included links. So, for example, if the website owner is supporting themselves with advertising, you haven't prevented anybody who wants to use these calculators from going there and putting their eyeballs on the advertising. So it's a different way to think about amount. This test was really built for thinking about text. You know, have you quoted 200 words or 1,000 words? That's what the amount and substantiality test was originally for. But the courts have been pretty good about applying it to the internet, and I think that's exactly what they would say here, that you haven't used it in such a way that it could substitute for the original. And of course, that's the next question, the impact of the use on the market for the original. Obviously, there's none. Unless, the only way you could have an impact on the market for the original would be if you said really bad things about one of them, and people stopped going to that site, and that, by the way, is protected by the First Amendment. And we have specific cases, they're in the context of book reviews. But somebody tried to use copyright to prevent a reviewer from writing a negative review that quoted the book. And the court said, no, 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 we won't let you do that with copyright. That's what fair use is for. We're not going to let copyright be used to suppress speech that is otherwise protected under the First Amendment. So that's the traditional analysis of fair use, and I think your use of the screenshots is actually pretty good.
Good.
But never mind, because in practice, courts don't do that anymore. Courts now ask themselves a different question. Yeah, go ahead.
I'm wondering if you've been following the Flickr controversy. And I don't know if
Pitch Flickr controversy.
Well, it seems like they came out recently saying we have commercial.
Oh, it's Instagram.
Oh,
it's Instagram that did that. Yes.
So are they trying to use fair use in their defense?
No, what they're trying to do is to say when you use Instagram, when you sign up for it, you agree to a set of terms of use. Remember my set of questions? The second question is there a license? Instagram creates a license. So does YouTube, so does Flickr, so does Facebook, so does almost every internet service you use. WordPress, although probably here if you're blogging for Duke, you're using Duke's enterprise WordPress installation, but if you get your own blog with WordPress or Blogger or anybody, you're agreeing to terms of use. Instagram announced that they were going to change their terms of use so that they would have the right to commercialize any photograph that was uploaded to Instagram. They could do that if they could get their users to agree to click on I agree. Remember, when you sign up for iTunes, you click on I agree, and I've actually printed out that contract. It's 30 pages long. You're agreeing to a whole lot of stuff. So if they could get their users to agree, they could do that. In fact, their users rebelled and they backed down. But that's really an issue of licensing. So that goes back to the second of my 5 questions. So partly because of the internet, are we supposed to stop at 1?
No, we have people who have 1:15.
That's fine. That's fine.
But no, we can go
I just
until
want to make
1:30.
sure I'm not supposed to shut up right
You're
now.
fine.
You'll regret that. In practice, courts are using a different analysis now. And it's partly been in response to the internet, although it actually arose in a different context that I will tell you about. They use a different approach. They look for whether or not the use is transformative. If you go back to those 4 factors that I told you about, they're really looking at the purpose and character of the use and really also the impact on the market. So they're asking, is the use transformative? I love the picture of the Dalmatian and the cats. I don't want to know how that happened. Right? But anyway, is it transformative? What do we mean by transformative? Are you making something new that will serve a different purpose than the original? Is that what you're doing? Your blog post, it's something new, isn't it? It serves a different purpose. It evaluates these creative calculators.
They may not like my voice either.
No, they may not. But it evaluates these carbon calculators. It doesn't replace them.
Right.
It's something new. I think it's clearly a transformative use. People will use your blog post for an entirely different purpose than what they would use the actual calculators for. I think it's transformative. This is why I say it's a risk analysis. Somebody who looks at your blog post says, if they're sophisticated about copyright, says this is fair use 2 different ways. Traditional analysis or the transformative use analysis. They probably don't even think that. They just look at it and say, that's fine. That's just not the sort of thing that we get to worry about. So there's very, very low risk. Somebody could still sue you. Somebody can always sue you. That's what we lawyers love. But it would be a waste of their money, and the case would probably be dismissed very quickly. They could write to you and say, we object to your using this, take it down. If you came to me as a lawyer, and I'm not your lawyer, but if you came to me as a lawyer and said, what should I do? I would say, thumb your nose at them. Because you have a really strong fair use argument here. Yeah.
I was just going to say, I think in those cases, it's good, for these folks to know, well, they're probably just going to ask you to take it down. But we did have a case with a photo that we used.
Yeah.
it was accidental. We pulled it down. We did not know that it had a copyright. In fact, we didn't think it did. And the photographer came after us.
Yeah.
Now, luckily, we used it at a thumbnail size, so the size was important. If it had been used at a size that somebody could have downloaded the original and reproduced it, even though it was a very generic photo, we were using it for an academic purpose, and we argued that we used it for an academic purpose. It was, an accident. We pulled it down, that it was at a size that could not be reproduced. Eventually he had to give up, but I literally spent a year of my time dealing with this man, and he even came after us with a collection agency. So our rule has been now that we don't use photos that we pull down unless they're government photos or stuff. But so it can be that something is simple. So I think you have to judge it depending on what the circumstance.
Yeah, and that's always true of fair use. And I think the reason that eventually he backed down was because there really was a strong fair use argument there. But that didn't mean he couldn't harass you and the university for a long time, because fair use is very uncertain, very easy to contest, and never absolutely certain until you get into court, which fortunately you never did in this case. But yeah, I think a big difference would be, and I actually don't, I know about the situation, but I don't know it in detail, so I don't know how much this was the case. The fair use case is much, much stronger if the photo, talking specifically about photos, is not just used as an illustration where any other photo of the same thing could be substituted, but is actually used as part of the fundamental point that's being made. That really strengthens the fair use case and makes it much harder for the person to object as strongly. So
in this case, we were using it for a very generic purpose that we could have pulled and put something else in.
So the fair use argument was probably weaker there because there was less of this sense of transformation. Nevertheless, I think it was fair use, and I think ultimately that's what even the photographer concluded. But I think it was a little weaker there. So I would say, and I do say all the time to groups that are asking me about using photographs, if you need that specific photograph because the thing you're doing doesn't make sense without that, because you're commenting on particular features of that photograph, for example, then use it, be confident that it's fair use. If you don't need that particular photograph, but just any picture of this, go out and find one that's licensed for you to use. Find a photograph under Creative Commons or something like that.
All right, you've got a question at the Marine Lab?
Oh, hi. Yes, hi.
So I just had a quick question. We use student photos a lot. Students give us their photos that they've taken while they're here. And so I'm just wondering, Scotty, with the issue that you guys had, like, what were the was it something that somebody had given you at some point and said you could use and then they didn't, or what was it?
No, this was one we just pulled down off the internet. So that's one of the reasons I was just warning you, and particularly the bloggers too, that if you went up and you pulled something down from the internet, you have to be certain that it's not copyright. And we thought in this case that it wasn't. So it was, we were really surprised to
Why did you think it wasn't protected?
Because we'd gone to a site that indicated on the site that the photos were, that we could download it. He must have gone after them as well, because we wouldn't have taken it from some site that...
That's another good reason for him to have backed down, though, because you would have had a defense there as well.
But the student photos that we use, we frequently, we ask people to sign something as they come in, that, or let them know that we're using these photos.
Yeah, and I think that's a really good practice. You actually don't even need, although as a lawyer I always advise you have something in writing, but you actually don't need even verbal permission. Even a lot of the web depends on what's called an implied license. So, for example, if I put a website on a server that I know is available to the public, I can't then come after you and say you shouldn't have looked at that. Because when you looked at it on your computer, you made a copy, because that's what computers do. They make copies in their cache, and that copy infringed my rights. I don't get to say that. because, and people have tried, believe me, the courts have said no, there's an implied license. If you put it on a server that's available to the internet, the copy that's made that it simply enables somebody to look at it is covered by an implied license. I'll give you a text example. I've occasionally written columns for the local newspapers. When I send them in, they never get me to sign a permission form. They're too busy. It happens too fast in the newspaper world. They assume that if I send it into the newspaper, they have an implied license to publish it. I suppose I could go back and sue them. It would be very odd, and it never happens to them. But so a lot of the web is based on this implied license. Student photographs, if they give them to you in a situation where the student knows or should know that you're going to use them in certain ways, you could probably rely on an implied license. Much better to rely on some kind of explicit license, even saying to the student, you don't mind if we use these on our website, do you? Much better to get a written release that just says, I give permission for my photographs to be used on a website, signed X. You're looking at me like I've... are you... I can't hear you if you're asking.
So my question was, so we're talking about being on the web. What about, is there a difference between web and print? So in our brochure, so and we've never had a problem.
Right.
But you know, a lot of students, they love for us to use their photos.
Right. And no, there isn't a difference between the brochure and the web. It might be a little harder actually to make the argument for fair use on the web because everybody can see it instead of just the people to whom the brochure is distributed. But in general, no, there's no difference. The chances are very, very low that a student is going to object, but the best way to absolutely be sure is to get some kind of either verbal or written permission. Just so they know before you do it, so they're not surprised. Up there I say many academic, and I'm going to go back to that photograph for a minute, many academic uses are transformative. Because what we do in the academy is take stuff that's already out there, the stuff of science or the stuff of culture, and comment on it, right? We use it to do something new. We comment on it, we create a new set of ideas, we evaluate websites, whatever it is. A lot of what we do is transformative. Having told you there were 4 factors in the fair use analysis, here are 3 questions to ask yourself to see if something is transformative fair use. That should say, am I? Am I making a new point? Right? Am I saying something different than the original said? Does the material help me make that point? Does this particular thing that I'm using contribute to the basic point I'm making? And did I use no more than was necessary to make that point? So let's ask those questions, and I'm guessing about your use of the photograph, but I'm gonna guess. Let's tell you what I think. Were you making a new point? Probably. You were doing something different than the photographer had done with his photograph originally. And you did use a reduced quality version of it. You didn't use more than was necessary. The problem was that the material really didn't contribute to the particular point you were making. That's what we were saying about you could have used any photograph. So that's where I think that I still think it was fair use. And you probably would also have a defense because of where you got the thing. But the fair use argument wasn't as strong as it would be, for example, in the case that Sarah was talking about, where she had to use those particular screenshots to make her point.
Now, would this apply in terms of music too? Because people are probably going to make videos and things like that. Looking at these 3 questions.
Right. Yeah, actually, that's a great question, and it's one I deal with all the time. So I want to make a video, and I want to use music as the background. I actually have a couple of video examples. I didn't bring them with me, and we'd probably run out of time anyway. But the same set of questions, I think, are really good, and especially that second one. There's a video that was made by a student here as part of the Frosh Life contest, where she uses, the video is about a very bad day at Duke. She's trying to hand in a paper and everything goes wrong. And each scene has a piece of music. So she misses the bus from East to West Campus and accepts a ride with a motorcyclist with his helmet down so she can't see his face. And a clip from Born to Be Wild by Steppenwolf plays. Clearly indicating this was a dangerous decision to make, risky, right? When she gets to West Campus, it's populated by a bunch of really muscular-looking zombies who are all wearing UNC shirts. And the theme from the Twilight Zone plays. When she finally gets to the library, the Gothic reading room, to hand in her paper, her professor is a cat curled up in the chair that transmogrifies into this professor, and the theme from Harry Potter plays. Now, all of those are copyrighted pieces of music, but all of them contribute to your understanding of the scene. They really do set the mood for each scene. So those particular pieces of music are really necessary to the point she's making in the video. And in each case, she uses only a short portion of it, only as much as is necessary for that scene, and then she moves on. I think that's clearly transformative fair use. On the other hand, if the music is just a soundtrack, if it just, fills the dead air, in those cases, I suggest getting licensed music. There's lots of music out there under Creative Commons licenses. If you don't need that particular piece, then get a licensed piece to use. But if it's got to be the theme for the Twilight Zone, it's clearly, I think it's much more likely to be a transformative use of the theme from the Twilight Zone. That's what I mean about does the material that you use help make the point. And music in videos is one of the best places to make this judgment. I do want to tell you briefly about some of the cases that have gotten us to this new view of fair use, because I think they're illustrative. Yes, I'll explain why each of those pictures is there. The first case that really used this transformative analysis was the Supreme Court. Again, it was a case involving a CD by the rap group Two Live Crew. They recorded a version on their CD called Nasty As We Wanna Be. They recorded a version of the Roy Orbison song, Oh Pretty Woman. That's why Julia Roberts is up there, because she's a lot nicer to look at than Roy Orbison, at least in my opinion. Anyway, they recorded a parody version of Oh Pretty Woman. It's kind of crude, it's very funny. And they got sued. Supreme Court said that it was a parody, that it was transformative, that it was serving a new purpose. The new purpose, they said, was to make fun of Roy Orbison's view of feminine beauty. That may be giving Two Live Crew too much credit, but that's what the Supreme Court said. I think they were just trying to be funny. But in any case, the court said that this was transformative, and they specifically said that it didn't substitute in the same market for the original. Right? I said somebody's not going to use your blog post instead of going to the website. Likewise, the court said somebody who walks into a record store, this was back in the late 80s when there were record stores, looking for Roy Orbison, isn't going to buy Two Live Crew instead. And likewise, no, I mean, it's absurd, isn't it? And likewise, if you're looking for Two Live Crew, Roy Orbison ain't going to do it. So that gives you an idea of where this idea of transformation comes from. In this case, the transformation was parody. So the court said they had to use Roy Orbison's song in order to make you understand what the parody was. And it didn't substitute in the market, so it was clearly a transformative use. The next point, the next picture, is James Joyce and his daughter Lucia. Lucia Joyce was institutionalized most of her life. She lived out her life in letters that she exchanged with her father. A scholar in Colorado wrote a biography of her, used a lot of her letters and Joyce's letters to her to tell the story of her life, which is mostly the story of her inner life, because as I said, she was in a mental institution almost her entire life. The James Joyce estate, which is administered by Joyce's grandson Stephen, is famously litigious. Basically tries to stop anybody from writing anything about the Joyce family, and sued to try and prevent this. Actually, they were successful insofar as the publisher pulled the book, and told the scholar that she had to remove all the quotes from the letters. She didn't want to do that, so she actually brought suit against the Joyce estate and won a decision that what she was doing was fair use. This is a classic example of she was taking short quotes from the letters, sometimes longer, sometimes shorter, and using them to build a different story, to tell a life, to tell the story of a life. Clearly transformative, classic academic use. The Joyce estate was not allowed to use his copyright, which has since expired, by the way, everywhere but in the United States, was not allowed to use his copyright to prevent her from doing that. Again, transformative use. The Grateful Dead. A book on the history of the Grateful Dead, it's called The Illustrated Trip, was published using 9 concert poster illustrations of concert posters from the Dead concerts. They were made part of a timeline. So at different points you see what the posters look like, because the posters were they were an art form in themselves. The publisher didn't get permission. They tried to negotiate permission with the archive that holds these posters, and they couldn't agree on a price. They went ahead and published the book anyway, relying on fair use. They got sued, and the court said they were right. It was fair use. Again, transformative. And here, the concert posters were shrunk. They were much smaller than the originals, and that made a difference. They were used to illustrate a timeline, to tell a history, not obviously to advertise a Grateful Dead concert. Very different purpose, educational, no more was used than necessary, really helped make the point that the authors of the book were trying to make. Fair use, transformative fair use. The elephant. I actually took that picture in Africa a couple of months ago. Had a wonderful time. But anyway, there is a very, if you haven't discovered it yet, very valuable site full of public domain books and digitized, a lot of the books that were digitized in the Google Books project that you can search. It's called the Hathi Trust. Hathi is the Hindi word for elephant. Because it's there to preserve these digital files. Elephants never forget. Hathi Trust was sued by by the Authors Guild, actually, for having and reproducing and making available to the public these digital files of scanned books. And very recently, a court ruled that that was a transformative fair use. People cannot read the entire book of copyrighted materials, although you can read the entire public domain books. But of copyrighted materials, you cannot read the entire book. But first of all, the thing exists to help preserve these books. And the court said that was a transformative purpose. People can search the text and find the words they're looking for in context to decide whether or not this particular book is helpful. You get a little snippet, about 2 lines of the book, around where the word you're searching appears. Court said that was a transformative purpose. Indexing was a transformative purpose. And Hathi will make these books available with the proper certification of a disability to people with reading disabilities so that they can use them in assistive software. And the court said that was a transformative purpose. And so in each of those cases, the Authors Guild lost their case, and the Hathi Trust, which is sponsored by 5 universities that were being sued as well, the Hathi Trust won the case, again, because it was a transformative use, a new purpose. The content was essential to the purpose, and no more of the content than was necessary for the purpose was used. Right? Those little snippets prevented it from being an infringement. So all of those are cases where courts have found fair use based on transformation. I'm nearly done, I promise. So you have plenty of time to ask questions if you want.
That's a question from New York.
Okay. I can't see you, New York. There you are.
That's okay. Here I am. My question actually kind of asks the opposite. I edit the Dean's blog, I edit the Illustratus blog, and with a fair amount of regularity, we post not just on our own blog, on National Geographic blog, on Scientific American, anyway, so we cross-post quite a few places. Mm-hmm. But because I have think facts now, I know every time someone takes our entire blog
Right.
And we post it somewhere where they're not authorized to do.
Right.
And, you know, it happened when I reported ABC News. It's pretty common on the internet. I don't, I'm not sure what we should do about that. I guess I'm curious about your opinion.
Right. And I was asked to say something about plagiarism, and I'll get to that slide in a minute. But in that case, first of all, you do have, or whoever wrote the blog has a copyright in that blog. If it's reproduced in its entirety, the first thing you can do is, if you want to prevent it, would be to have a letter sent to the person who runs the other website and say, take it down. Well within your rights to do that. Of course, you always, as the copyright holder, would make the decision, is it worth it? Do I benefit from it being there, or do I resent the fact that it's not there? You could also send a letter and say, look, we're happy to have you use it. Please credit us. Please say that where it originally came from. And you can use the force of copyright law to make somebody do that.
They do tend to credit us.
I'm sorry?
They do tend to credit us.
Okay.
So usually they'll say Bible Shemidas, they originally posted on Huffington Post, usually they grab stuff off Huffington.
Right.
So to me, it's bad on the one hand, it's really poor form on their part. On the other hand, it can actually distributes it a little bit wider, even though it seems completely wrong for them to do so.
Right. Well, it is probably wrong in terms of copyright for them to do so. But a lot of the time, people make exactly the decision you're talking about, to say it's not, you know, it means that a few more people will see it, and it doesn't do us any harm, so we're not going to prevent it. So I think that's a perfectly reasonable decision. You could make the other decision. You could say, I'm going to enforce my copyright. I'm going to use the threat of copyright litigation to force them to take it down, or, I mean, you would have the right to bring a suit in federal court. I'll take a minute to say something about that. Copyright is federal law, which means it's always decided by federal courts. So lawsuits over copyright are brought in the federal district courts. In order to bring a lawsuit alleging copyright infringement, your work has to be registered with the United States Copyright Office. Now, most people's works, and certainly blogs, are almost never registered with the Copyright Office. So let's imagine that you wanted to bring a lawsuit, and your blog has not been registered, your particular blog post. Well, what you could then do is first submit the blog post to the Copyright Office for registration. Then once you have the registration, you can bring the lawsuit. The damages you could get will be significantly reduced by the fact that registration didn't happen until after you discovered the infringement. If you really want to make money off of infringement, you need to register as soon as the work is created. But it does not mean you can't bring a lawsuit. You could. You would just have to register first. But I mean, I think the decision that you're making, that it doesn't do you much harm, is a perfectly reasonable one. But yeah, you do have the right to use copyright law to your advantage if you want to. Yes?
I have a question about registration. So since I have a blog, do I register the whole blog at the same time, or because I'm constantly adding content, is it more a matter of registering each individual blog post?
Well, that's one of the problems. The system that we have was created for static content. It understands text, it understands film, it understands even software. One of the funniest things is that software in the United States is registered as a literary work. The reason was because when people started submitting copyright software to the Copyright Office for registration, they did so, naturally enough, as printouts of the code, you know, with the sprockets on the side, the way we used to print. And the Copyright Office said, oh, well, it's written, so we're going to call this a literary work. And it's still the case that software is registered with the Copyright Office as a literary work. But the copyright system and the registration system is not well adapted to works that are continually changing. It's just not what it understands. By doing away with the requirement of registration, we accommodated that a little bit. Because each post you write is protected, even without registration. It's not required at all anymore. So you still have the copyright protection. Really the only advice, unless you expect infringement and expect to want to bring a lawsuit, it would be you would have to register each new bit of content. And it would be ridiculous to do that, as you said. So in fact, what you will probably end up doing is taking advantage of this ability to register after the infringement and bring a lawsuit if you had to. I've put up there some things about liability for copyright infringement, and I said that you can get up to $150,000 per act of infringement, which is why I told you that you could be liable for $300,000 for those 2 screenshots. The fact is that that's called statutory damages. That means that instead of having to prove how much money I actually lost because of your infringement, which is almost impossible to do, I can just claim the amount of money that the law has told me is allowed. And the law says it's up to $150,000 per act of infringement. However, I lose that ability if I haven't registered my copyright before the infringement happens. I lose the ability to claim statutory damages. So if you have to sue over infringement of your blog, either one of you, you would have to actually prove the damages, prove financial damages. That's very hard to do. And so it would probably discourage you from bringing those kinds of lawsuits. And that's a result of the fact that, the whole system does not understand things like blogs that change constantly. So it makes it very unlikely that you would want to bring that lawsuit because you probably could not make enough money to make it worthwhile. And the last thing I had to say, and it's 1:30, I've already said a lot about it, about the difference between copyright infringement and plagiarism. I suggested that one of the things you could do in the case of your website or your blog would be to force them to insist that they give you credit, and you said they usually do. Of course, as long as they give you credit, it's not plagiarism. It may still be copyright infringement because they're not the same thing. Plagiarism is always cured by acknowledging the original source. It's done. It's not plagiarism anymore if the original source is acknowledged. It can still be copyright infringement even if you acknowledge the original source. So they overlap. You can do something that is both infringement and plagiarism. You can take somebody else's work, use it in a way that's not fair use, and not give them credit. That would be both plagiarism and copyright infringement. You can take somebody else's work, use it in a way that's not fair use, and give them credit, as apparently these folks are doing with the blogs. And that is potentially copyright infringement, but not plagiarism. And what I usually tell people is the best defense against plagiarism, on the one hand, is always to give credit when you use other people's work. That's just a basic rule that everybody should know and everybody should follow. And when you put your own work out there, boy, that's kind of spelled funny. When you put your own work out there, make sure that it has clear information about who created it and how to get in touch with you, so that somebody who wants to use it can give you credit, and they can ask you for permission if they're using it in a way that is more than fair use. That does not guarantee anything. I'm sorry, there are no guarantees in life. That's not going to ensure that you will never be subjected to plagiarism or copyright infringement, but they are good steps to take. And I'm going to stop there because time's run out. I told you I'm bad at leaving time for questions at the end.
Thank you.
Thank you. That was excellent.
Thank you.